she's being harassed by all of these postings. And, whether you view her as a saint or not, no one should be subjected to that form of harassment.
Hello, everyone, and welcome to the next episode of Beneath the Law. My name's Gavin Ty. I'm with my partner and friend, Stephen Teal, and we get to pick a few cases that have come our way that we've come aware of that we think are interesting and hope you think they're interesting too. The case we're going to talk about today is really got some strange twists and turns to it and a lot of layers of issues in it, but it deals with a real societal ill and societal problem, particularly in the digital age in which we live in, where communication platforms like Facebook or Instagram or whatnot are used for really awful purposes and addressing some of the basest of human instincts. In that, I'm talking about is cyberbullying and the really insidious practice of bullying that goes on place online, sometimes with really terrible results. And the effect that has on people. And that is a real problem, and one that at least one jurisdiction in Canada has sought to address through legislation, and that province is the province of Nova Scotia. And the case that we're going to be talking about deals with a application under the Nova Scotia legislation to take down, if you will, a postings or a Facebook page that had been brought forward specifically targeting one individual. So, Stephen, maybe you can give our listeners a little bit of a background on the facts of this particular case.
Sure. Thank you, Gavin. Great to join you once again, and to you, the listener, for joining us once again. So, yes, this case has a lot of layers and almost reminds me like of a Lord of the Flies kind of community where they're taking the law into their own hands, so to speak, with respect to the applicant in this case. So the applicant had been previously charged years ago with animal cruelty. And I guess she had developed... Pardon me?
She was convicted.
Yeah, she was convicted.
Yeah, she was not...
right.
I don't think we're talking about, like, in fairness, let's just step back. When we think about cyberbullying, we think about a victim and we think about perpetrators. This particular victim I have to say, Stephen, is not making me shed a lot of tears, even crocodile tears, because she was just not a nice person. I mean, I'm a dog lover, and she was convicted of cruelty to dogs. I don't know if she ran a puppy mill, or I don't know what the background was, but she had been convicted of animal cruelty and assaulting a peace officer a number of years ago. And then what happened, and I don't mean to interrupt you, just sort of a quick background, a bunch of people found out about her, and I guess there were a lot of dog lovers out there who similarly weren't very impressed by this particular individual, and they set up a Facebook group where they proceeded to rant, for lack of a better word, about this nasty person.
Well, it's vigilante justice over the internet. You're absolutely right that the community members, somebody set up the respondents set up a Facebook page, stop this person. She mistreats animals. Beware, watch your dog. This applicant is around and may steal your dog. Then you have people who see this on Facebook who are allowed to post comments. Some of the comments was somebody should shoot the person, somebody should beat the person to a pulp, that they'd be willing to do it. They basically were putting her under surveillance. By the way, watch out, she's in your area, watch your dog. And, so she's being harassed by all of these postings. And, whether you view her as a saint or not, no one should be subjected to that form of harassment. And so she went to court and sought an order to get these Facebook posts removed. And so the legislation, I think the legislation, Gavin, quite honestly, is great because, people are entitled to the protection of their reputations. And, certainly you can speak about someone and if you don't have a great impression of them, that's one thing. But to take it beyond that, to begin to say that she should be physically harmed because of her past conduct, that's inappropriate.
No, I agree with that 100%. I think that is exactly the point here, was that saying that this particular individual was, you're entitled to your opinion of them. The fact that she had been convicted of animal cruelty in the past is a fact. This is a person who had a history, obviously, of cruelty to animals, and there are a great many people who feel quite passionately about that. And that is something that they're, of course, free to discuss. But when you come to the point, as you mentioned, where you're saying, we're going to kill this person or we're going to hurt them, to the point, I think the evidence before the court was, at least in the decision, was that this was causing this individual serious anxiety. They were fearful for their safety as this mob-like frenzy on Facebook was whipped up with all of these insults. And quite frankly, who knows who was going to take that to the next level and take it offline and then take it into the real world and actually carry out some of these threats that are made online.
And that's, Gavin, to me, the very real danger. Once you get a group of people talking about doing something, it kind of feeds on itself. And in the end, somebody decides, yeah, I'm going to do that.
Yeah. The digital lynch mob.
It reminds me of those old movies, where you're watching people storm Dracula's castle with pitchforks and torches.
Yeah. Well, they were getting
here's
pretty
somebody
wound
that
up.
we don't like in the community. Let's get the monster, so to speak, mentality. And, really, that's what cyberbullying is all about, right? It's a group of people sit around. Oh, we don't like A because, they don't dress the way that we dress, or they don't have, their hair is not nicely combed or whatever. And then people get together and they start chatting on whether it's Facebook or texting on TikTok, whatever social media they can use. And that's a form of bullying. And it has very real ramifications to the person who's not necessarily well liked by others, and creates mental anguish. People get suicidal, Gavin. They get depressed. There are people who counsel others. Hey, you better kill yourself. That's how bad it gets. And quite frankly, I mean, this case has, as you say, a lot of layers to it. Those are crimes in Canada, right? No. Under our criminal code, you cannot harass people. I think the legislation in Nova Scotia basically arises out of, somebody posting images, explicit images of someone, and she saw that and ended up killing herself, right? So we now have legislation in Canada that protects that and makes it a crime to do those sort of things. You break up with your boyfriend, you break up with your girlfriend, all of a sudden you're posting images of that person. You can't do that. That's wrong.
Yeah, I think that those are all extremely important social goals, and I think that was the intent of the legislation. It's always troubling to me sometimes when you see the law in action, and where you get a situation like this person, where unfortunately I think that there's another societal good or objective that may in fact be legitimate, that is obviously taken too far here. But there, you'll often hear from people that they have a right, for example, to know if there's someone in their community that has a proclivity to commit an offense, if they were involved in child molestation, for example. People want to know if those sexual offenders, for example, are in the neighborhood, so to speak. And I would expect that many of the people in this Facebook group felt the same way about animals, and dogs in particular, and they wanted to know whether this type of person was in their neighborhood. So when they take it to that next with their pitchforks and torches, that's a different story. But I think that I hope that the good intention and the good purpose of the legislation is not lost because it is applied in this particular instance to someone who is frankly probably not that sympathetic in the greater scheme of things to most people. They are someone who is not a particularly, upstanding individual, apparently. But they don't deserve to be threatened. They don't deserve to be fearful of their life either.
Let me ask you this, Gavin. You're a very prominent civil litigation lawyer, and you have a client that comes to you with respect to all these kinds of postings on the internet. And here in Ontario, what can you do about it, right? Versus, we have a legislation here in Nova Scotia that actually gives a right away to somebody. But in Ontario, would those postings last for a long time? Like, what would you do?
In this particular instance, I think you really only have two options. You could bring an application to a judge to get an injunction that they be taken down, or you could sue for defamation. Or in this particular instance, I do think, though, that if there are threats online, I'm going to kill this person, for example, the answer is call the police. It is a crime to threaten someone's life in Canada. And if the police knocked on the door, that would stop. Now, in this particular case, though, what we had was, and this is where we get into the real layers, the individual applicant went to court on her own, had no lawyer. She filed her own materials. She brought an application to have these postings taken down under, I don't even know if she noted the Nova Scotia legislation. She got to court. The administrator of the Facebook page was served, but never showed up. So we had an unrepresented applicant on an unopposed application, and an order went that the posts be taken down. But what was interesting, I thought, and I think it's a real issue that goes far beyond this legislation, is when we have the number of unrepresented litigants in the system right now is mind-boggling. The cost of litigation is such that most people can't afford to pay a lawyer to deal with something that is a personal issue like this, and fund it all the way through. So, and in this particular instance where we had an unrepresented litigant on an unopposed application, when you read the decision, the judge hearing it kind of took upon herself to go one step further. And she actually did the legal research herself, to frankly make out the applicant's case. And that is a little troubling, don't you think? That when the judge takes it upon themselves to act for, in a way, the applicant to achieve the remedy.
I'm not sure about that, Gavin. In the case of an unrepresented litigant, that a judge's role should be limited to only hearing the cases that the other side has to offer. In this case, there was really no other side, as you said. The person who was posting these, who had created this Facebook group, wasn't before the court because she never responded. And courts, I've often seen courts take it upon themselves that they do additional research. Now, some judges get criticized for doing that, because what they end up doing is they add an argument that was never raised before them. In other instances, they're basically just applying the law that was not put before them by the lawyers involved. And I don't think that that's necessarily wrong. You've probably been involved in cases, Gavin, where a court or a judge has said to you, if they are concerned about the precedents or the cases that are presented before them, or the issues, to say, look, I haven't really seen the law on this. Can you go back and provide that to me?
Yeah, I think that's absolutely a proper role of a judge. Just stepping back from this particular instance for 1 second, I think a judge is right to be concerned if, for example, a case that the judge believes is relevant has not been brought forward by counsel or by the parties, and particularly where you've got unrepresented parties. And I think it's perfectly appropriate for a judge to say, for example, what do you have to say about case XYZ? How do you say that applies or doesn't apply? Those are appropriate issues. And in fairness, I think that in thinking about this, and I think the position of a judge, judges were lawyers before they were judges. For the most part, most people go to law school because they want to help people. They want to advance the law. They want to stand up for people's rights. And I think judges never really lose that. And then when they get into a courtroom situation, it's kind of the natural instinct of any lawyer to sort of root for the underdog, if you will. And if someone's unrepresented in front of them, and you think they've got a meritorious case, to kind of help them along. I think that is a natural instinct of most lawyers. And as I say, all judges were lawyers and are still lawyers. So, I think that these are issues. I think that it's a little troubling to me sometimes when a judge steps over the line of being a judge and sort of comes across as more as counsel to one party than the other. And that is certainly what occurred here to some extent, because the judge went off and did the research under the Nova Scotia legislation, put a number of authorities into the decision that I am quite certain, and I think the judge was candid about, were never referred to by anybody. So the judge came to her own remedy here, appropriately, I think, taking down the offending Facebook page and ordering the administrator to do that.
Well, and that's what I really find very interesting about the case. Certainly a judge should never climb down from the bench to insert themselves as an advocate of one side over the other, just as a matter of basic principle, in my view. But what I find really interesting about this case, Gavin, is the Nova Scotia legislation is designed in such a way that the party who's bringing one of these applications doesn't need to identify who the poster is of the harmful comment. So, in this particular case, the facts are that the posters were other people. They weren't the person who had set up the first Facebook page. It was other people in the community that had posted the comments. And normally, in a defamation case, if I come across a website where someone has posted a defamatory comment, I need to bring my action against that particular person, not the person who's hosting necessarily the website or, let's say Google or Facebook or Yahoo. I need to be able to identify who the person is before I can actually bring an action. So, we talk about process, and you talked about an injunction. Well, the first step in that kind of a case is you actually have to bring a motion to get the identity of the person. So how much cost are you incurring, to protect your reputation? And that's what I really like about the Nova Scotia legislation, which I think really is a shining star in Canada as legislation that other provinces should be looking at to protect people. Because, you talked about going to the police. Here is a person who was found guilty of a crime, and I think part of it was assaulting a peace officer or something. She's going to go to the police station. and make a complaint about this Facebook group? Is she honestly going to be believed by the police? So it would have been, I think, a little bit difficult for her to go to a police station to make a complaint. So she found this remedy in this piece of legislation to at least prevent any further damage from going forward.
Right, and it's important that that's exactly the guts of the decision. Was that the test of in the legislation that the court referred to was that the communication must, and I quote here, must cause or be likely to cause harm to another individual's health or well-being. And the judge came to the conclusion that posts that contained, and I get quoted again, graphic threats of harm to the plaintiff personally, whether by assault or with a weapon, those were the types of threats that, quote, are likely to cause harm to the plaintiff's health or well-being, and because of the fear and anxiety that they would entail on that plaintiff. So that's where the judge got to, and that was the, I think, positive and useful societal goal that the legislation was sought to achieve. Again here, though, that it is an interesting case. In this regard, let me ask you this question. This has always been my experience and troubling to me. It's all very nice to get an order against someone like Google or Facebook. How do you enforce it?
I'm troubled by that because, most of these companies, first of all, they're not located in Canada. And, they may be, I guess they're located in the United States, but, some of these other companies who are less well known are located in some other foreign jurisdiction. And how do you get them into Canada? And you've got conflict of law issues, which are very complicated, but you also have freedom of speech protections in some of these other jurisdictions. The United States is a very, very strong country for protecting freedom of speech. And so is an order in Canada going to be looked upon as being contrary to the public policy of the United States when you're asking somebody to take off or take down a posting on a website that is, under the umbrella of a U.S.-based company?
I think that's a huge issue. First of all, let's just break that down for a second. Enforcing an order from Canada and the United States is generally a challenging exercise because although there is this notion of full faith and credit in the U.S. and certainly here in Canada, I do think that American courts kind of look sideways at orders from Canadian jurisdictions. And I think it is a process to get them enforced, number one. Number two is I think many of these big tech companies, for example, Facebook, or I guess it's called Meta now, they don't really care. Trying to write to Google, for example, as just but one example, to take down defamatory postings that are found on their search engine is basically like instead of putting a message in a bottle on a desert island. I mean, good luck. They just don't respond.
I think, in fairness, some companies are better than others, but it strikes me more that the companies who are not as well known certainly take an attitude that, regardless that they have procedures where you can make a complaint to take down an offensive post, will simply ignore it. And you can get sometimes the police involved, or even their policies will say, well, you need to go through a police force. We're not listening to anybody else.
Precisely.
And so if the police doesn't care, because let's face it, a posting on, a defamatory posting, well, that's not a criminal matter in most circumstances. That's a civil or private matter. The police aren't getting involved in that. They've got better things to do.
Exactly. It isn't a crime, and the police will generally not be involved in that at all. And I agree with you that many of them do not respond to private citizen complaints about it. And I also agree with you that there are invariably, in many of these sites, internal procedures that they require you to follow in terms of complaint handling, adjudication, etc., which may or may not yield the result. All the while, of course, the harmful postings are on the internet literally for everyone to see anytime they'd like to. But there are companies, I suppose, that specialize in trying to remove those at the same time as well. But the Nova Scotia legislation is extremely interesting and important because I think what your point is that it actually makes it effective and easier for victims to have the harmful content removed by the actual person who had posted it in the first place, or the administrator of the Facebook page in this particular example.
Yeah, because it makes one person responsible for all of the content. And so if in Nova Scotia, if you're the person who's running some chat group that's public, or you're creating a Facebook group, be aware that you're responsible for the content that's posted on that group. And you need to vet. If you're going to take on the responsibility to set something like this up, you need to monitor what's going on.
A little bit of responsibility is important, and I think particularly in the age of social media, where so much damage can be done under the cover of anonymity and pseudonym, and if this legislation does curtail that a bit and bring some personal responsibility back to social media, good on it. Well, thanks, Stephen. That was a great topic and a great, very interesting case where sometimes a good results come out even if you don't particularly like the people, because you're a dog lover like I am. But it's a good result, an important societal issue, and a great discussion as always. And thank you all for participating and listening. Hope you enjoyed this episode of Beneath the Law. And as we're fond of saying, if no one is above the law, everyone is beneath it. Hope to hear from you and hear from all of you, and please give us your feedback and comments. We're real rookies at this, and any suggestions are gladly read, and hopefully we can make this even better as we keep bringing you Beneath the Law episodes. Stay tuned for the next one.